Good evening, this is Christine Rucha, and I will be discussing the Moseley versus Victoria's Secret Catalog Incorporated case. This is a trademark infringement case. To introduce the Mosleys, in 1998, they decided to open a store in Elizabethtown, Kentucky, a retail store that sold men and women's lingerie, adult videos, and sex toys. Kathy and Victor Moseley are husband and wife, and they decided to name their store Victor's Secret. They were the only employees in their store. Victoria's Secret is nationally known. They have 750 stores nationwide in the United States. They have been registered and trademarked as Victoria's Secret since 1981. They sell lingerie, clothing, and other accessories. They have 2 stores located within 60 miles of Elizabethtown, Kentucky, that have been open since 1982, and the second one since 1985. As of 1998, they were estimated to be $1 billion company. So on February 12, 1998, there was a weekly publication that was distributed to residents of a military base in Fort Knox, Kentucky. It advertised the grand opening of the Moseley's store, Victor's Secret, just in time for Valentine's Day. An Army colonel caught glimpse of this and wrote to Victoria's Secret as he perceived this to be an attempt to use the company's reputable trademark. The company wrote to the Mosleys and requested under the trademark and the name that they change the name so that it not cause confusion. The Mosleys changed the name slightly where they added Victor's Little Secret. However, Victoria's Secret was still not happy with that change in the name. It didn't suffice. So they went ahead and moved forward with filing suit with the federal district court against the Mosleys. They filed 4 separate claims against the Mosleys. The first one was trademark infringement, alleging that petitioners' use of their trade name was likely to cause confusion and or mistake in violation of United States Code 15, Section 1114. The second claim was for unfair competition, alleging misrepresentation in violation of Section 1125. The third claim was for federal dilution in violation of the Federal Trademark Dilution Act. And the final claim was for trademark infringement and unfair competition in violation of the common law of Kentucky. So initially, the Federal District Court and Court of Appeals both found that petitioner's trademark had tarnished the Victoria's Secret mark. Both parties moved forward for summary judgment. The Moseley's motion for summary judgment was granted. The district court found Victoria's Secret to be blurred and tarnished. The Mosleys, in response to this injunction, changed the store's name to Kathy's Little Secret. However, they went ahead and they appealed to the appellate court. The case ended up being presented to the U.S. Supreme Court. The U.S. Supreme Court granted certiorari to decide whether objective proof of actual injury to the economic value of the famous mark was necessary for relief under the FTDA. Certiorari is when a party is seeking to appeal to the Supreme Court from a lower court decision. They must go ahead and file a writ of certiorari. If 4 justices agree to review the case, then the court will hear the case. So in the case of Moseley versus Victoria's Secret, they agreed to review the case, so they were able to have a court hearing at the Supreme Court level. Victoria's Secret did not prevail. On remand, they will be given the opportunity to show actual harm either through direct or circumstantial evidence and may ultimately prevail in this dispute. However, because of this case, this brought to light for future federal trademark dilution cases, plaintiffs must go to court ready to present reliable evidence of actual dilution of the famous mark in order to prevail under the FTDA. Unfortunately, Victoria's Secret was not able to provide circumstantial or enough evidence to prove otherwise, to prove the dilution of their mark. And Kathy's Little Secret is actually still in business today. Thank you for your time.